Good morning. My name is Holly Griggs, and I'm the Program and Active Aging Specialist here at the Wood County Committee on Aging, and I want to thank you all for joining Part 3 of our Constitution 101 series. These presentations are being recorded and can be accessed at any time through our website and YouTube. At this time, I would like to introduce our speaker, Judge Matt Reger with the Wood County Common Pleas Court.
Thank you, Holly. Before I go into what we talk about today, I talked about last time, so I have 1, 2, 3, 4, 5, I have about 10 pocket constitutions. Holly, I'll drop those by the senior center. Is it open? Can I walk in?
Yes, yep, temperature taken and stop in at the front desk, wear a mask.
I'll drop these off at the front desk about 1 o'clock today.
Okay.
So anybody who wants a copy of these can have them. So any of you who are participating, I see our numbers have gone down to 3, but I know that there's other people watching. Today, I want to just do a sum up of last time. The first time we met, we talked about the foundations of the country. Basically, we started with the French and Indian War, and that the British expenditures on the war caused them to have to do what we would call additional taxation on the colonists to pay for the war. And that was perceived by the colonists as being excessive, particularly when taxes were passed without representation. And that leads to the Declaration of Independence. And as we talked about, and I want to articulate that out there, I'm going to be talking about an idea that's not spoke about a lot, not talked about a lot, but I think it's implicit within our cultural and legal history. We have a Declaration of Independence that says that we are endowed by our Creator with certain unalienable rights of life, liberty, and the pursuit of happiness. So what that says is that we talked about this a little bit. We talked about Thomas Hobbes and John Locke, 2 theories on government. Hobbes believes that you enter into government to protect yourself from yourself, basically, that there's this self-interest and people only act in their self-interest, and that the government can be an absolute power and can take away any rights. So all rights are subject to the government when they enter into it. Locke says, well, when you enter into it, people are naturally are good, but they need government to create order and to get rid of chaos. And but when entering the government or society, that they retain rights, they hold back those rights, and those rights are similar to the Declaration of Independence of life, liberty, and Locke never said pursuit of happiness, but life and liberty are retained. So you've got this idea of retained rights, which is inherent within the Declaration of Independence. Then move forward now to 1787. We adopt a constitution. When we adopt the Constitution, we include in it a due process clause in the 5th Amendment. The 5th Amendment says that life, liberty, and property may not be taken away from you, but through due process. So what that says is that life, liberty, and property can be taken away by the government, but only through due process. So it's not an inalienable right. Well, within this enumeration of rights, the first 10 amendments, and remember when the Constitution was adopted, the first 10 amendments, or the Bill of Rights, was a part of a compromise. The smaller states were willing to have a representative body that did not give them the ability to have, I want to back up. Remember, we had several compromises. The first compromise is that there were 2 plans. There was a Virginia plan and a New Jersey plan. The Virginia plan said that we have 2 bodies, legislative bodies, both represented by the percentage of people who live in that state. So that unduly gave extra power to those states with more population, such as Virginia, New York. The New Jersey plan said, no, every state gets one vote in a unicameral system. Ultimately, they come up with a compromise, and the compromise is two houses, one a population representative, the House of Representatives, and then the Senate, which is each one of the states gets 2 votes. So that's the compromise. But in regard to making that compromise, the other compromise was, remember, understand that at the time of the founding of the country and at the time of the creation of the Constitution, the greatest fear of the public was the government. And so there was this enumeration of rights within the Bill of Rights that set out those rights. So we have the First Amendment. Well, the First Amendment encompasses 6 rights, basically: free press, free speech, assembly, free exercise of religion, establishment clause, and then petition the government. And then we have the other rights in the Second Amendment, Third Amendment, Fourth, Fifth, Sixth, Seventh, and Eighth Amendment. The Ninth and 10th Amendments, though, are a little bit different, and that's where I want to at least go over that for a minute. The Ninth Amendment says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, the Ninth Amendment buys into this Lockean theory of retained rights. Maybe buy in is the wrong word. It accepts the idea that there are retained rights, rights that are not enumerated in the Constitution, but are retained or held by people. Article 10 or 10th Amendment says the power is not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectively, or to the people. So it's saying that powers given to the government, the very limited powers, those powers are the only powers that the federal government has, and any other powers not listed belong to the states or the people themselves. Understand that these 2 amendments were meant to restrict the power of the federal government. There was a deep fear of the federal government and a centralized government. So understand that in that context, is that these 2 amendments are meant to do that. So we've adopted now the Constitution. We've adopted the Bill of Rights. Now we move forward through history. And that brings us to the Civil War. The Civil War is results because we weren't able to deal with the central issue of the time of the adoption of the Constitution, which was slavery. We weren't able to eliminate it, and we weren't able to figure out a way to get rid of it. And so that becomes the central issue of the Civil War. We have the Civil War. Following the Civil War, we have what we call the Civil War amendments. The 13th Amendment eliminates slavery. And then in 1868, the 14th Amendment is adopted. The 14th Amendment, at the adoption of it, I don't know if you've looked at it recently, but it does several things. And I'm going to read section 1 of it. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So right there it's saying that what the intent of this was saying that all people who were born into slavery are citizens now of the United States. They are full privileged citizens. It says this: no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law. So that Fifth Amendment protection is now incorporated into the 14th Amendment. But what it says is that nor shall any state. So what it does is it takes that due process provision and applies it to the states. Now, that opens up a complex legal issue. And before we go into that, I do want to open it up to any questions as to where we are. You may have some questions right now about where I'm going or where I'm moving forward. So let me at least put it in context. We've adopted the Constitution. We've adopted the Bill of Rights. We've had the Civil War. We now have a 14th Amendment. which provides a due process clause that's applicable against the states. As I said before, the Fifth Amendment's due process clause only applied to acts done by the federal government and not to acts done by the state. The 14th Amendment now applies to acts done by the state against its citizens. So I'll open up to any kind of questions before I move on. Anything? I see nothing right now, and maybe I've lost you. Okay, I'm hoping not, but if you want to text some questions along the way, that's fine too. So the 14th Amendment's adopted, and I believe that at the time that it's adopted, that the people who are in the House of Representatives thought that they were making it so that there is some procedures to protect against the acts of the state. You know, basically understand what's going on at that time. States are acting on their own. So it's 1868. It's now 3 years after the war. States are going to be joining the Union. We're in the Reconstruction period of time. And there's an understanding that states, even though the United States has eliminated slavery and has enfranchised African Americans, the states are the ones who are responsible for voting, for all kinds of different things. And if the states decide that, well, we're not going to give African Americans or former slaves the right to vote, the federal government has no ability to force them to do it, and the 14th Amendment provides that. The 14th Amendment also provides something that you may have been familiar with or what you've heard about is equal protection. Basic idea is that everyone is entitled to equal protection of the law, that a law cannot treat people unfairly or discriminatorily based upon certain, unless there's some kind of substantial state interest. So let's move forward through the interpretation of the law. There's with the 14th Amendment's due process clause, there's two schools of thought. There's under what's called the incorporation doctrine. What the 14th Amendment says is that the protections under Amendments 1 through 8 are applicable to the state through the incorporation of the due process clause. Now, some judges have argued during this, and when I'm saying this, this is from 1868 forward, okay? There's a line of judicial theory that says that protections under the first 8th Amendments are incorporated piecemeal, meaning one at a time. So the right to free speech is just the right to free speech through the 14th Amendment if the judges decide that it is incorporated. And what that means is this. If a state, let's give you an example. If the state of Massachusetts says that you can only speak on certain topics in public, we would obviously say that violates the First Amendment. But it doesn't violate the First Amendment alone. The First Amendment only applies to acts of the federal government. The only way it applies to that state is through the 14th Amendment. Now, some judges argue that this incorporation only happens case by case and article by article of the amendments. Other judges said, no, wait a minute, no. When the 14th Amendment's passed, it's fully incorporated. Every protection in the first 8 amendments are applied to the states. Well, ultimately, what wins out is basically a piecemeal incorporation. Over time, different amendments are applied to the states. First Amendment in different portions, then the Fourth Amendment, the Fifth Amendment. The Sixth Amendment has never been applied completely. So, for example, the right to a grand jury has never been fully incorporated. The only right that a person has to a grand jury is whether that state provides it. For example, the state of Ohio provides a right to a grand jury, but it doesn't come through the United States Constitution. So we've got this development of laws and we've got the development of it as applicable against the state. And because of the 14th Amendment, we have a proliferation of cases involving the first 8 amendments. Understand that the first real and substantial First Amendment cases don't come until after 1868. That goes the same for Fourth Amendment, Fifth Amendment, Sixth Amendment. All of these challenges to those amendments come after the 14th Amendment when it's applied to acts of the state. So that comes to, and that's where I'm moving forward to Griswold versus Connecticut, which is a 1965 case. Before we get there, I want to give you a little history. So I'm giving you history on the Constitution. We're going to give you history on a little bit of a law. In the middle part of the 19th century, when the Industrial Revolution was going on, primarily after the Civil War, Industrial Revolution was growing. Cities were becoming big factories, and a lot of factories were developing. I think if you know a little bit about your history, you know about the proliferation of industrialization. Industrialization was, and as it would naturally, cause some problems to the family unit. All family members were working, as you know, children were working in factories, mothers, fathers, everyone was working in factories. There was some, I would say, legitimate issues of the destruction of the family or tearing down the family because of these new roles. Government thought it was its responsibility to take care of those roles. And one of the roles they were doing was to eliminate the use of contraception and abortion procedures. And in particular, the state of Connecticut had the most strict requirements. And theirs eliminated the ability to use, to talk about, or any way address the use of contraceptives. The law was passed in 1872 as part of what was then known as Comstock Acts. Comstock was a U.S. representative who had applied what was then the Comstock Law, which was to eliminate the dissemination throughout the United States of contraceptive information or abortion information. And in Connecticut, that particular law, a very strict law, was passed with the help of a guy named P.T. Barnum. You probably know P.T. Barnum from the circus. Well, P.T. Barnum was also a very moral person who promoted morality and wanted laws that promoted morality. And so he promoted this law, and that law was passed in 1872. That law remained the law until 1965. Now, several times throughout the 30s and 40s, there were attempts to challenge the law. In 1961, ultimately, there was a plan to challenge the law, which was adopted by Estelle Griswold, who was the director of a Planned Parenthood in New London, Connecticut, and also a Dr. Byton. Well, what happened was they intentionally provided contraceptive information to a married couple. They knew exactly what was going to happen, and they provided it to a married couple with the intent of creating a case. Understand that no case can come before a court unless there's a controversy. There has to be a controversy. So I want to stop for a minute. There is a good question here. How does the 14th Amendment deal with Indians? Well, that's a broad question, I guess. Carol, if you want to broaden it or kind of make it a little more specific, I'd be happy to answer that. I mean, in regard to the 14th Amendment, Indians are Native Americans, or Indians are entitled to the same citizen rights as any other citizen. They are protected under all aspects of the United States Constitution. They are also, though, allowed to have their own country. Reservations are basically a separate country. To give you an example of that, I worked with some Native American judges, and when a judge in a Native American reservation interprets the law, they interpret it according to the law itself as it's written, the Constitution, and then Indian culture and history. I don't know if that answers it, Carol. If you have something more specific, please indicate. Or if you want to text something else, that's fine. But I hope that gives some kind of provision. So I've kind of laid it out. Law passed in the 1870s about banning all contraceptives and banning all communication on contraceptives is passed. Estelle Griswold in 1961 establishes a Planned Parenthood clinic to provide this information out, and her and the doctor that she's working with intentionally provide it to a married couple. And the reason they chose a married couple, because the courts were going to have a tougher situation dealing with the providing of contraceptive to a married couple. They would have no problem rejecting it from an unmarried couple, particularly in the time that we were talking about. So the case is they're charged and they ultimately are fined each $100. It's appealed. It goes through the Connecticut appellate process, and then ultimately it's brought to the Supreme Court. There's a nice question here. No case can be brought up without controversy. Does controversy also have to include harm done to an individual? Yes. Okay, so that was one of the issues in the Griswold case that was summarily decided right away, which was, did they have what we call standing? And you have to have standing. So you have to have some interest in the case. You can't be bringing the case just to have a decision brought up. You have to have some interest, some kind of, and yes, they disarmed, because they were fined, that was going to be the interest. So the case is brought up. The side challenging the law is saying, under the Due Process Clause, there should be this right to disseminate this material, because the Due Process Clause should protect the marriage. And so when the Supreme Court comes out with a decision, and it's interesting, the decision is written by Justice Douglas. So I need to kind of give you a little idea of how the Supreme Court decides how a decision is written. Decisions are written by certain judges based upon their seniority. So the most senior person is always the Chief Justice. In this particular case, the Chief Justice was in the majority. This is a majority, so I want to understand this, okay? Give you the broad picture first. The law is found to be unconstitutional in a 7-2 decision. So there are 9 justices on the Supreme Court. In a 7-2 decision, it is determined to be unconstitutional. But that 7-2 decision is divided into multiple decisions. The opinion of the court, so what would be the majority opinion, is written by Justice Douglas. He's joined in that, or at least Justice Clark votes in favor of that. But Justices Goldberg, Warren, and Brenner agree with the final decision to find it unconstitutional, but through a different process. Justice Harlan also agreeing with the result, but once again, through a different process. And once again, Justice White also agreeing with the result, but through a different process. And then ultimately, Justices Blacks and Stewart have a complete dissent. I'm going to walk through those. And I think this is important because this encapsulates some ideas that I think are important to talk about. So the decision is written by Justice Douglas, who delivers what's called the opinion of the court. Justice Douglas is a controversial figure. I'll start out there. He's appointed to the court in 1940. He is one of the youngest members ever appointed to the United States Supreme Court. He's also the longest serving member of the Supreme Court. He served on the Supreme Court until 1976, so a period of time of 36 years. And I want you to think about that, is that Justice Douglas was appointed to that seat in 1940. His replacement was Justice John Paul Stevens in 1975 by Gerald Ford. Justice Stevens stayed on the court until his replacement was appointed by President Obama. So think about that time period of how that seat's been filled. So I've told you about the case, at least the conflict. It's not a complex case in regard to facts. A married couple is provide contraceptive information. And the people who provide it are prosecuted under the law. Now it's before the court, there's arguments presented, and then the Supreme Court makes its decision. Justice Douglas's opinion finds that there is what he calls, and I'll read it to you. He suggests that there are specific guarantees in the Bill of Rights that have penumbras, meaning like an umbrella, formed by emanations from the guarantees that help give them life and substance. This is probably the centerpiece of why this decision is so controversial and complex. Justice Douglas points to no provision in the United States Constitution that protects the right to privacy, but he says it emanates from all the other rights that are within the Constitution. So, for example, he says the right to free speech applies not just to words that are spoken, but to those that are written, those that are thought, right to distribute, right to receive, the right to read, the freedom of inquiry, freedom of thought, freedom to teach. Indeed, the freedom of the entire university community comes from or emanates from the First Amendment. He also indicates that the right to association that's within the First Amendment, although not clearly stated, emanates from the First Amendment. He also says that the Third Amendment, prohibiting against the quartering of soldiers, has a right to privacy aspect of it. The Fourth Amendment affirms the right to be secure in the person's house's papers and effects. The Fifth Amendment self-incrimination clause also creates a zone of privacy. And then also, he states that the Ninth Amendment provides the enumeration of certain rights not construed to deny or disparage others. So what he's saying is look at all these rights under the Constitution, look at how they've been interpreted. Under that whole thought of these rights, there's this penumbra, this umbrella of rights that emanates from the written rights and therefore give us the right to privacy. So basically what he's saying is, look at all the rights, they've been expanded, and because they've been expanded, that means that there's this right of privacy, and that's what it emanates from or is created out of. That is the decision of Douglas. That decision does become basically a foundation to what becomes Roe versus Wade. Now, the other judges, and that's why I think it's important to look at Griswold versus Connecticut, because Griswold versus Connecticut, I'm trying to get to, Griswold versus Connecticut doesn't get into the fineness of what the law is about. The law itself, everyone agrees, is a ridiculous law. What it goes into primarily is the constitutional issues. And that's why I think it's an important one to look at and probably gives us a better context. So Justice Douglas's opinion is basically, you know, all the other ones have been expanded, expanding all of those, basically expanding upon all those rights that we have and that we've enumerated over time. There is this right of privacy that can be implied. And so that's his decision. Well, Justices Goldberg, Chief Justice Warren, and Justice Brennan, they like the result, but boy, they say, I don't agree with saying that it emanates from all these other rights. That just doesn't make sense. No, I think that it's a retained right under the Ninth Amendment. they say that, you know, the Ninth Amendment says that it's a retained right, and so that's what this should be decided on. Okay, one of the things they point out was, and this ties back to what we talked about. The makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. And inherent with that is the right to marry. Although the Constitution does not speak in so many words of the right of privacy in marriage, I cannot believe that it offers these fundamental rights no protection. And so what they're saying, what Goldberg, Warren, and Brennan are saying, well, it's a retained right. It's a right that's held by the people. We're not going to buy in completely to what Douglas is saying, that it emanates from all these other rights. We just think it's got to be a right that's retained by the people and always existed. It's something that the Declaration of Independence listed as basically an inalienable right, a right that can't be taken away. Well, then there's Justice Harlan. And Justice Harlan says, you know what? I think you guys are all wrong. I think the 14th Amendment, I still agree with the end result that the law is unconstitutional, but I think it's just the Due Process Clause. The Due Process Clause protects values implicit in the concept of ordered liberty. It stands on its own bottom, is what it says. And so Justice Harlan says, just look to the 14th Amendment. The Due Process Clause says that the idea of ordered liberty requires a right to privacy. Well, then there's Justice White. And Justice White says, you know, you guys are all getting lost. I really think it's just the due process. It deprives liberty without due process of law. Clearly, that's what happens here, is that liberty is being taken away from people, and it's doing it without due process. So there are basically the 1, 2, 3, 4 opinions of the majority. Justice Douglas emanates from all the other rights. Justices Goldberg, Warren, and Brennan, Ninth Amendment, it's a retained right. Justice Harlan, it violates the whole idea of due process, which in a free society, there has to be a right to privacy. Justice White, no, it deprives liberty without due process. Now, I want you to think about this. We've got 1, 2, 3, 4, 5, 6 justices. All have different ideas of how to get to the same right, looking at the same Constitution. Before I get to the dissent, any questions? Have I gone beyond anybody? I mean, I understand these are complex things, and maybe I'm not doing so in a way that really conveys it, but I'm hoping I am somewhat. And if you have some kind of question, please bring it up. So finally, I want to go to the dissent. The dissent is by Justices Black and Stewart. And Black and Stewart begin with this, and it's very good. States, in my view, this Connecticut law as applied to married couples deprives them of liberty. No, I'm sorry, I'm reading the wrong one. Justice Black, here it is. I agree with my brother Stewart's dissenting opinion. Like him, I do not extend whatever base my view. Okay. Basically, he says, Black and Stewart say, the law is stupid. This is a stupid law. But the Supreme Court is not meant to decide whether or not laws are stupid. They're supposed to decide whether laws are constitutional or not. And they believe that although stupid, it doesn't violate any explicit part of the United States Constitution. They say the Constitution says nothing about a right to privacy. All the other judges are creating a right of privacy. They're having a hard time. They can't figure out where it actually comes from because it's not written anywhere. And here they are, they create this right to privacy when there is no right to privacy written in the Constitution. And therefore, it's not our job to create a right of privacy. That's the legislative job. So understand what Black and Stewart are doing. They're saying, hey, there's a division. Our job is to determine whether or not a law is constitutional. The only way we do that is by looking at the Constitution and see if there is something in the Constitution that says right to privacy. If there's nothing in the Constitution, then we have no right to create a law or create something that the legislature, that it falls within the legislature's responsibility to do. And so that is the decision of Black and Stewart, or at least the dissenting opinion of Black and Stewart. I think that's important to know and to understand that there is a legitimate and ordered thought within this. It has nothing to do with policy or ideology. It all has to do with the law. So everybody has a basis in what they're coming from. But Black and Stewart are saying, no, this is not what the Constitution wants. Now, I do want to talk to you about something that goes back a little bit in time. And it's the thing that we continue to argue about today, is that do we interpret the Constitution as written, or as it evolves? And what happened was we married two systems together. As I said, when we founded this country, we married it. We wrote a constitution. We had a written constitution, but we married that with a common law system. And understand that common law system comes from Britain. All British, former British colonies, all British colonies still work under what's called a common law system. The common law system is that judges interpret the law, and therefore that's how you look at the law. That's why England has what's called an unwritten constitution. Their unwritten constitution is the collection of all of their laws and statutes together with legal opinions that form the basis of their law and their constitution. We decided to take a written form of constitution and marry it with this common law system and of judicial decisions. And by doing that, we created where they would interpret. Justice Douglas is completely correct that the right to free speech is broader than just saying words. It applies to the writing, it applies to disseminating, it applies to publishing, it applies to thought. And one of the other things they argue in here is that, and in that decision, they talk about different rights that are out there. The right to send your children to the school that you wanted to. There's a case called Pierce versus Society of Sisters. It's an early 20th century case where the state of Oregon had passed a law prohibiting people from sending their children to anything but a public school. Obviously that's challenged. And then it goes up and the Supreme Court says, hey, you have this right to send your kids wherever you want to send them. That's your right as a parent. It is not explicitly written in the United States Constitution, but it can be interpreted from it. And so that's what Douglas is saying. Goldberg, Warren, and Brennan are saying, yeah, but it's not written in the Constitution, so therefore it has to be out of that 9th Amendment. Okay. And so, well, okay, now, and so there's all of these, this is how the different opinions are out there. I guess now I want to open it up to some questions. I see that you talked about Citizen United versus FEC, money as speech. If you want to, next week we can go through Citizens United. I can talk about that and talk about free speech. I think that the Supreme Court has been very consistent in protecting free speech, and free speech is a very essential part, and they've been very broad. In many of the cases, understand that protection of free speech is something that is pretty much unanimous on the Supreme Court. Now, we can talk about that, but what I wanted to do was I wanted to talk about Griswold today because I think it encompasses a lot of things within constitutional law that are helpful to think about. Questions? Anything? Okay. I read an interesting article, Perversion by Penumbras. Yeah. Well, you know, it's kind of interesting is that, so I will tell you that there's a famous Justice, oh gosh, just a minute, I'm going to, so Justice Clarence Thomas has a sign that says, please do not emanate into the penumbra. And what he's saying is that Douglas went too far in creating a right of privacy out of the penumbra of rights. Many attorneys believe that, or many legal scholars, I think, would agree that the Ninth Amendment probably is a more solid base of that, is to say that, you know, the Ninth Amendment, it's a retained right, and there's a better foundation constitutionally for that. So now the thing is that by the culture of the day, new norms by the public and so on, is the Constitution a living document? Well, I think the Constitution is a document that's alive. I do believe that you have to look at the context of what it was how it was written, and then you have to look at how the decisions have interpreted. I mean, as a judge, what I do is, so somebody comes to me with the Fourth Amendment. The Fourth Amendment protects against unlawful searches and seizures. Well, then I look at how the cases have interpreted. How have other judges interpreted it, and then I apply it as that. I'm pondering how associations are defined. Well, they didn't get into that to say that marriage was an association. And so let me read to you what the First Amendment says. Congress shall make no law prohibiting, respecting an establishment of religion, or prohibiting the free exercise thereof, abridging of the freedom of speech or the press, or the right of people to peacefully, the right of the people peacefully to assemble and to petition the government. So the First Amendment says nothing about association, but it does say the right of people peaceably to assemble. Well, the First Amendment has been interpreted over time to protect the right of association, the right to associate or be part of any group you want, implicit within that free speech. So think about it this way. One of the cases that expounded that right was a provision in a state law that did not allow attorneys who had belonged to the Communist Party to become attorneys. Well, when that came up to the Supreme Court, the Supreme Court said, well, that violates free speech in regard to it violates a person's right to associate. There's no question in my mind that the Constitution has been interpreted over time, expanded, and given broader rights. There's no question that certain things that were not thought of in 1787 are given rights. So for example, recently this was discussed. In, oh gosh, it's been 15 years ago, I think, there was a case involving the scanning of a house. So you take a heat scanner, you scan a house, and the provision to the question to the US Supreme Court was, is this an unlawful search and seizure? In doing the analysis under that, Justice Scalia went and looked at what the idea was of the founders when they created the Fourth Amendment. And although that electronic scanner was not available in 1787, he can look at what was their intent, what were they trying to protect? And therefore, then from there he would say, well, they were trying to protect the privacy in a home. A scanner of that kind violates that privacy and therefore is subject to the Fourth Amendment. Marriages, okay, so there's a question there. Are marriages to be handled the same way as corporations? Well, okay. We're really mixing a lot of law that's really not there. The FEC, the Citizens United case, had to do with free speech and not in regard to the right to privacy that we're talking about here. And I don't want to mingle those. I'll tell you what I'll do is I will pull out the Citizens United and we'll talk about that next week. And try to give you some contextualization of that. Other questions about the right to privacy, as I talked about it in Griswold versus Connecticut. I encourage you to maybe do a little of your own research on Griswold versus Connecticut. I don't know if you want to read the case itself, but there's some summations out there that might help you out in understanding it or getting a better understanding or grasp of it. So that's what I would at least tell you to do. You know, we have an hour and I'm talking about some pretty complex, large issues and how that affects. Now, one of the things that it did not extend to unmarried couples. Griswold versus Connecticut was decided primarily in the context of married couples. The ideas that Douglas articulated have been used to expand to the protections that have been afforded to the right to marry in the Oberfeld case. And but understand the right of privacy has only been extended to marriage and to the idea of abortion and contraceptives. Also, idea of law equals sin is fascinating. Also, idea of law. I guess I don't know what that statement is. Also, idea of law equals sin is fascinating. I guess I don't know what you mean by that. Got that from the perversion by Penumbra's paper. Oh, okay. Yeah, that's an interesting comment. So is there anything else? Any other questions? I know that I've talked about something pretty quickly that is a complex issue. I hope it's given you a little more insight into what is really still a complex issue for all of us and still being debated. But what I want to, I guess, I hope you walk away from this is that judges, and lawyers, people in the legal field, they have their ideologies and beliefs and political persuasions. But when we get to the law, we try to look at it and how it's been interpreted. Those things influence us, but I really think that, at least I try to, apply the law as it's written and as it's interpreted. My obligation is to look at how other judges interpreted it and apply the law in that way. You know, the example I can give you is this. A person is stopped by a police officer. And in that stop, it impacts the Fourth Amendment because it is an unlawful, it has the possibility to be an unlawful search and seizure. In my job in determining whether something is an unlawful search and seizure is to look at how it's been interpreted by other judges and the written decisions of those judges, and to see how that works within the context of the Fourth Amendment and the ideals of the Fourth Amendment. And that's how I do with anything else. Griswold versus Connecticut presented a complex issue to the Supreme Court. They knew where they wanted to be, but really in trying to get there, they were having a hard time finding a way of getting there. It would be nice if the Constitution wrote it out, but it doesn't. It wasn't intended to do that. And I think that understanding that gives you a little bit better, I guess, comprehension of what attorneys and judges go through. I think it's about time for me to go. I do appreciate the time. As I said, I will be recording next week. And so what I'll do is I'll record a presentation on Citizens United versus FEC. I was trying to, and then I'll give a wrap up to everything from there. Okay?
Awesome.
And then if you'd like further about this, please contact the Senior Center and maybe we can do it another time. Okay?
Thank you for taking the time out of your day to do this for us, Matt. We really appreciate it.
Thank you very much. Have a good day.
Thank you.